Thank you. General Burr, you issued a press release on the 27th of November 2020 with respect to administrative action. Can you please define administrative action and its purpose within the military justice system?
Administrative action is one of the three elements available to us, obviously criminal law, disciplinary law and administrative action, which as a service chief delegated from the Chief of Defence, I have the ability to make decisions around maintaining the professional standards, the good order and discipline of the Army, and it is upon using that administrative law that I took the action that I did.
Okay, so in a report of this committee, The Effectiveness of the Military Justice System, it was June 2005, but I think is still very relevant today. It comprehensively covered, especially in Chapter 13, disciplinary and adverse administrative action following other action, and it was very clear in that chapter. And in particular, I draw your attention to paragraphs 13.8 and 13.10 of that report, where particularly 13.10 looks at both disciplinary and administrative components of the military justice system, showing that they are two separate systems with their own distinct procedures, offences and penalties. And it states the committee would be concerned if administrative action were used solely because of a perceived difficulty in successfully prosecuting a particular breach or offence. My question to you is, General, are you using administrative procedures to deal with alleged breaches or serious misconduct on the battlefield in Afghanistan?
The purpose of the termination notices that I issued was to take an even-handed approach to all those whom credible information was identified at odds with ADF expectations and values. The opportunity for respondents to offer their perspective is provided as a matter of procedural fairness. That is the basis by which
And you
I
gave
acted.
them 14 days?
The standard, the default setting is 14 days, but they can apply for an extension. All applied for an extension, and that was granted.
So we sent these men to war. Presumably they were subject to the laws of armed conflict and what I believe to be the terms of rules of engagement. Now, like Vietnam, I expect that there were many scenarios where our SAS were in situations when it was difficult to determine who the enemy were. Why are we taking action, and in particular harsh administrative action, after a protracted inquiry against men we sent to war, and given the severity of termination as a possible outcome of administrative action, surely these men should be given the right to due process of a trial where any evidence and witnesses can be tested?
And that is the difference between, I guess, the criminal process and administrative process here. As the Chief of the Army seeking to uphold professional standards in the Army, there was sufficient credible information contained in the Brereton Report that gave me the justification to take the action that I did. Procedural fairness is offered, as everyone has the right to respond, and for my delegate to consider that and make the appropriate judgments. Once a decision is taken, the right of appeal remains through the redress of grievance process, including going to the Ombudsman if that's deemed necessary.
General, at a time, I mean, we can, the best legal minds in this country sit on the High Court, and there are often 4-3 decisions. And over my time with 20 years with the Australian Government Solicitor, the Defence was one of my main clients. I have real concerns about the use of administrative action to deal with alleged breaches of conduct during warfighting. And at a time where so much is being made of the presumption of innocence and the rule of law, we're hearing it every day, surely a court should decide these matters, particularly against any individual, and most especially in relation to these 13 individuals. So I am concerned, given the public comments that have been made, that in effect the case against these people, given the public comments that have been made by a range of different people, that they've already been hung, drawn and quartered, and they're not going to be afforded the presumption of innocence and the rule of law that is so much being bandied around at the moment in relation to other matters. General, a comment?
My job as the Chief of the Army is to ensure that I uphold the standards expected of service in our Army. There is sufficient credible information in the Brereton Report that allows me to take the action that I have.
And in the process, will these people be afforded due process of law?
That is something I can't answer, but that is a separate process requiring different levels of evidence to achieve any form of prosecution.
So the processes that you've put in place, one would assume, would afford them appropriate due process and presumption of innocence?
That's correct.
Is that what you're saying, yes or no?
There is due process applied to the administrative processes we've put in place.
Okay, thank you, General.